Good afternoon. My name is Jacob O'Neill. I'm the Chancellor of the William Minor Lyle Moot Court Board here at UVA. On behalf of the board and on behalf of the University of Virginia School of Law, I'd like to welcome you to the final round of the 84th Annual William Minor Lyle Moot Court Competition. The Lyle Moot Court Competition is UVA's premier program for oral advocacy spanning a full 2 years. Beginning in his second year, a competitor joins about 100 of his classmates in a competition designed to develop legal writing skills, oral advocacy, and effective representation. The competition demands the highest standards of preparation and skill, and we're proud to showcase today 4 students who have weathered 5 grueling rounds of competition and who represent the best our school offers in oral advocacy. Without any further ado, I'm going to turn it over now to Mr. Jonathan Urich, our final round presiding justice.
Good afternoon, everyone. I'd also like to welcome you all on behalf of the Moot Court Board to the final round. Like Jacob said, the competitors have come really far to be here, and so we're really happy to have you all here to watch them compete. If you could just take a quick second just to turn off cell phones, make sure everything's on vibrate. They don't have to be off, as long as they're not going to make noise during the competition. That's all I ask. And now that that kind of housekeeping logistical announcement is behind us, let me introduce the 3 distinguished judges that we have judging today's argument. So the first judge we have is the Honorable Bernice Donald, who was nominated in 2011 by President Barack Obama to the United States Court of Appeals for the 6th Circuit. Judge Donald received her law degree from the University of Memphis School of Law, and from 1995 until joining the Court of Appeals, she served on the U.S. District Court for the Western District of Tennessee. Judge Donald also served as a U.S. Bankruptcy Court judge for the same district from 1988 to 1996, making her the first African-American woman in America's history to serve as a bankruptcy judge. When Judge Donald was elected to the Tennessee General Sessions Criminal Court in 1982, Judge Donald also became the first African-American woman to serve as a judge in the entire state of Tennessee. Judge Donald is extremely active in the American, Tennessee, and Memphis Bar Associations, serving in vital leadership roles and on key committees. And in August of 2011, she concluded a 3-year term as secretary of the entire ABA. Judge Donald has served as faculty for numerous international judicial and legal training programs all over the world. Our second judge this morning is the Honorable Stephanie Thacker, who was nominated also in 2011 by President Barack Obama to the United States Court of Appeals for the 4th Circuit. Judge Thacker graduated Order of the Coif from West Virginia University College of Law, where she served as an editor of the West Virginia Law Review. For the 20-plus years that Judge Thacker practiced law, she worked both in the civil and criminal litigation areas. Judge Thacker served as a federal prosecutor for 12 years, both at the United States Attorney's Office for the Southern District of West Virginia and at the DOJ in the Child Exploitation and Obscenity section. While with the Department of Justice, Judge Thacker rose through the ranks from trial attorney to principal deputy chief of her section. For her service, Judge Thacker was awarded the Attorney General's Distinguished Service Award. Following her tenure with the DOJ, Judge Thacker joined Guthrie and Thomas in Charleston, West Virginia, where her practice concentrated on complex litigation, environmental and toxic tort litigation, and criminal defense. Finally, our third judge this morning is the Honorable Paul Watford, who serves as a circuit judge on the United States Court of Appeals for the 9th Circuit. He was nominated by President Barack Obama in late 2011 and confirmed in May of 2012. Judge Watford received his BA in 1989 from the University of California at Berkeley and his JD from UCLA, where he also graduated Order of the Coif and served on the UCLA Law Review. After law school, Watford clerked for Judge Alex Kaczynski on the 9th Circuit and then Ruth Bader Ginsburg at the United States Supreme Court. From 1997 to 2000, Judge Watford served as an AUSA in Central California and Los Angeles. Serving in the criminal division, he prosecuted a wide range of federal criminal cases, including complex white-collar cases, as a member of the major fraud section. From 2001 until his appointment to the bench, Judge Watford was in private practice at Munger, Tolles, and Olson in Los Angeles, where he focused primarily on appellate litigation. I'd like to thank all the judges for coming today. We have a great, fantastic panel of extremely qualified appellate judges, and their participation truly enhances the competition both for the school and the competitors, so we're really proud to have them here today, and we're really appreciative. The problem that will be argued today was written by Chase Cooper, and it is the case of Halcyon, Inc. against Alan Decker. Last year, the U.S. Supreme Court recognized a ministerial exception to employment discrimination claims in Hosanna Tabor versus EEOC. The court in that case held that the religion clauses of the First Amendment prevent the government from requiring a religious organization to accept or retain an unwanted minister, or for punishing it for failing to accept or retain the minister. The court expressly declined, however, to decide whether that ministerial exception extends to breach of contract actions by ministerial employees. Petitioner Halcyon claims to be a religious organization entitled to the protections of the religion clauses. Halcyon began as an alternative to Alcoholics Anonymous and similar 12-step programs, emphasizing reliance on a higher power and intimate daily relationships with other persons in recovery. The organization eventually expanded, however, its scope beyond recovery from addiction and now seeks to aid all persons with their physical, mental, and spiritual troubles. In 2003, Respondent Alan Decker signed a 10-year employment contract with Halcyon to be terminated only upon good cause. After Mr. Decker was fired in 2007, he brought this lawsuit in the state of Lile seeking damages for breach of contract. The Supreme Court of Lile concluded that Halcyon could indeed be sued because it was not a religion as a matter of law, and furthermore, the First Amendment does not prohibit a court from deciding the breach of contract claim. The U.S. Supreme Court granted certiorari on those two questions. First, whether Halcyon is a religious entity entitled to the protections of the religion clauses, and does the First Amendment prohibit a court from deciding on this breach of contract claim. Andrew Mutter and Matthew Glover represent the petitioner Halcyon, and Archit Ramkumar and Lyle Kosis represent the respondent Alan Decker. And so thank you guys again for attending. We're really happy to have you all. We're really happy and appreciative again to have such distinguished federal judges here. The competitors, the advocacy that you're going to see today is extremely high quality advocacy. These are the best advocates that our school has to offer. They've come extremely far. And without further ado, we will now open court. All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting.
You may be seated. Before the court this afternoon is the matter of Halcyon, Inc., petitioner against Alan Decker, respondent. The parties are ready to proceed. We will hear from the respondent, and I would ask, if you wish to reserve time, please let me know how much time you, the petitioner, wishes to reserve for rebuttal. We're ready to hear from you.
Madam Chief Justice, and may it please the court. My name is Andrew Mutter, and I represent petitioner Halcyon in this case. I will address whether Halcyon qualifies as a religion under religion clauses of the First Amendment, and my colleague Matthew Glover will be addressing the ministerial issues. I would be speaking for 13 minutes, 14 minutes for my co-counselor, with 3 minutes for rebuttal. Your Honors, I have two main arguments I would like to address. Halcyon is clearly a religion for the purposes of the First Amendment because it fundamentally rejects a secular worldview in favor of an overtly religious worldview grounded in the belief in a higher power. Second, none of the objections that respondent raises strips Halcyon of its First Amendment rights, particularly the protection of the church autonomy doctrine and ministerial exception, and therefore those should bar this claim. Turning to my first point, petitioner urges this court to do here what it has always done by holding that the starting point of a religion clause analysis is by distinguishing secular thought from religious thought, not as respondent urges.
Well, this court has never defined religion with any specificity. How would you have us define religion?
Your Honor, we would have this court define religion in keeping with prior precedent as the belief in a higher power or a transcendent reality and nothing more. We believe that is consistent with this court's holdings, for instance, in Wisconsin against Yoder, where this court said there may be multiple ways of life, both secular and religious. What makes a religious way of life protected under the religion clauses is that it stems from faith. Therefore, the distinction between religion and non-religion for the purposes of the religion clauses should be that faith, that belief in a higher power.
Doesn't the way of life here stem from addiction and recovery more than a faith-based doctrine?
Your Honor, respectfully, we would argue that the facts indicate that the entire basis of the Halcyon way of life is religious in nature. Miss Davidson, when she was dealing with addiction, went to AA and found solace there, but specifically began to reject the idea that a secular worldview could help one through one's problems. So just because the origin of Halcyon was dealing with addiction, the basis of its belief is still religious and exclusively religious.
Traditionally, when we have looked at religion and religious institutions, haven't we generally said that they deal with beliefs and sort of end of life or afterlife situations, and have as their core this fundamental belief in the higher power, but more than that, in sort of life and death situations?
Respectfully, Your Honor, the first prong of the Africa test does suggest that a correct analysis would be to begin with an ultimate concern question. One of the things that courts have signaled, maybe that ultimate concern would be with life and death. However, to hold that a specific belief about life and death is necessary for a religion to be a religion would strip a number of already well-established religions of their First Amendment rights and their status as a religion. For instance, Buddhism does not specifically, or some strands of Buddhism does not specifically deal with or focus on afterlife or life and death, rather focuses on the temporality of the individual and acceptance of that temporality. Likewise, Judaism, for a number of years in its very early inception, had no specific concept of life after death and a specific formulation of afterlife. So the question that petitioner urges this court to look at is simply not what kind of ultimate concern questions are asked and answered, but whether there is something ultimate and transcendent that is the primary concern of the religious organization.
Even if we approach this in the manner you suggested and apply our focus where you've suggested, what do we do with these other issues that are surfaced in the memos about tax consideration issues and things of that nature? Do we take a totality of the facts and circumstances, with the ultimate question being one, but also the motivations being another?
A couple of points on that, Your Honor. First, Halcyon does not contest that its nature as a for-profit organization does not allow it to be taxed under IRS regulations. This court has held in Jimmy Swaggart Ministries that religious organizations can be taxed just as secular organizations can be, and that decision is left up to the legislature. Halcyon is urging that the ministerial exception and the church autonomy doctrines are not on the behest of the legislature like that taxing decision is. So for-profit status may have some effect, and indeed it may mean that Halcyon can be regulated under equal employment opportunity against Smith under neutral application. Sorry.
You know, I'm asking you, when you're arguing that this should be characterized as a religious, I mean, Halcyon's activities should be characterized as religious, and this should be a religious institution. And in making that determination, I'm asking, how do we evaluate the factors in the memo, such as, it could be argued that the whole motivation here was not to be a religious entity, in fact, but simply to move toward this status for a specific tax advantage.
Respectfully, Your Honor, a petitioner urges this court to consider Halcyon as a religion from its inception, not just the Ascension Memo as being a time in which it shifted from some other status to a religion.
How can that be? Where in the, prior to the Ascension Memo, is there any indication that this was a religion?
Your Honor, while the specific category of religion versus religious organization may be troubling, this petitioner urges this court to look at the nature of the activity. As this court is held in Bellotti, it is the nature of the activity that is asserted that should be considered, not the status or certain labels that's put on the organization, such as religion or such as just a religious organization. We believe that
Judge Donald was beginning to point out, the nature of the activity here, particularly pre-Ascension Memo, was to sell product and real estate.
And while that might be one of the activities, Your Honor, that Halcyon engages in, the purpose of that activity has always been religious. Mrs. Davidson created her religious communities not in order to profit, but in order to expand her religious mission and vision on this earth.
What is it in the record that would support your statement that those activities were designed to be religious? What is it in the record that would support that, other than your argument?
We would direct the court to the record at 24, I believe, where it establishes the nature of Mrs. Davidson's belief in rejecting the idea that a purely secular worldview would work, and rejecting the idea even that just a loose affiliation of people is helpful in overcoming some of life's worst problems. She believed that you need to believe in a higher power, you needed to have a daily communion with it, and in fact you needed a community, a strong community around you every day supporting you in that decision and moving along down that path of a religious path.
And if that's enough to characterize this as a religious institution, and we hold for you, wouldn't that entitle any privately held commercial organization that happens to offer any kind of religiously based product or services, wouldn't that entitle them to some protection under the First Amendment as a religious institution? And where do we draw the line if that's the case?
Yes, Your Honor, we would be suggesting that those organizations that are giving a religious product may, in certain very limited instances, come under the protection of the religion clauses.
So a book publishing company that sold religious books, among other things, would then be entitled to be characterized as a religious institution for these purposes?
It may be characterized as an organization that exercises religion in some meaningful way. And whenever a court is addressing an issue, a claim that turns on the free exercise rights of individuals to choose their ministers and the free the critical court incapacity to decide religious doctrine, the ministerial exception and the church autonomy doctrine may apply. For instance, in the Maroney case that we've cited in our brief, the District of Minnesota there was faced with an organization, a secular for-profit company that employed Jewish slaughterers, kosher slaughterers, and their decision, that court held, to release one of those slaughterers because they were not fulfilling their religious obligations was not reviewable because that would require a religious determination. So it wouldn't necessarily be as expansive in the purely secular for-profit company situation as we would argue it is here with Halcyon, because that for-profit secular corporation is not necessarily a free associative body of believers.
Well, can you articulate the test that you would urge the court to use in evaluating whether it's a religious institution or not? Give me the test that you would argue the court should apply.
So we would suggest that a truly religious organization that may have the full breadth of ministerial exception would be one that is brought about by the free association of religious adherents. There are over 500,000 Americans and 1.8 million people worldwide that ascribe to Halcyon as their religion. That is their choice. They choose to have Paul Singer, the CEO, to be their leader and their head over them. They choose to engage in the services of Halcyon with the technician services, and they choose to live in the Halcyon communities.
And this is the test that you're articulating now that you would argue for the court.
That might make the distinction, Your Honor, between a religious associative body and a religious for-profit corporation. That might be the critical distinction, the associative rights.
It seems like Halcyon Inc. falls into the maybe religiously oriented for-profit corporation side. I mean, I'm willing to grant you that Halcyon might be a religion in the eyes of the believers, the followers of Sheila Davidson, but everything else about the operation strikes me as just an ordinary business. I mean, I don't know of any religion that pays their ministers, or their so-called ministers, $2.5 million a year plus a bonus based on the revenues generated by the enterprise. That just nothing about that strikes me as a religious institution.
With respect, Your Honor, we would hold that kind of determination that criticizes a religious organization's financing decisions is not something that this court has traditionally allowed courts to inquire into. There are a number of religious organizations that have very different financing structures. Indeed, one of the oldest contests between Martin.
But wouldn't you have to have already decided that it was a religious institution to say that you don't inquire into that? I mean, it seems to me that's kind of circular.
We would assert that the first inquiry for this court is whether or not the organization is exercising religion and whether or not that is a religion under the First Amendment. The second inquiry might be whether or not that this is an organization brought about by the free association of religious adherents. And we would suggest that the financing decisions of that religious organization, as long as they are legal, as this court held in the United States against Ballard, in that case.
So you're arguing that it's inappropriate for us to look at the financing structure as one factor in determining whether or not it is a religious institution. That's what Justice Watford said.
Yep.
That's one factor he's looking at in determining whether or not there is.
Your Honor, I see that I've run out of time. Do I have permission to briefly answer?
Please.
Yes.
Okay.
We would hold that, yes, that financing decision by that organization is not reviewable as long as it is legal under United States against Ballard, because that would be looking into the veracity and the veracity of the claims of the religious adherents and not to the nature of its religious activity itself. For the foregoing reasons, Your Honor, Petitioner respectfully requests that this court reverse the Supreme Court of Lyle's decision below and hold that Halcyon is a religion under the First Amendment. Thank you.
Thank you, Counselor. You'll have your 3 minutes for rebuttal. You may proceed.
May it please the court, my name is Matthew Glover and I also represent Petitioner Halcyon. I will be addressing the ministerial exception and church autonomy doctrine questions. Halcyon had the sole province to terminate Mr. Decker's employment as a minister within their organization under both the ministerial exception and the church autonomy doctrine. Turning first to how...
So you're going to address whether Mr. Decker in fact was a minister?
Yes.
So I guess one question I have just right off the bat is how can someone be a minister if they don't themselves believe in the faith?
With respect, Your Honor, the determination of who is a minister, as this court suggested in Hosanna Tabor last term, looks at whether that person forwards the message and mission of the religious organization inwardly and outwardly. And so Mr. Decker held that position, and at the time that he joined Ms. Davidson, he knew that this was not a standard recovery organization as he had previously worked for. He knew that this was a recovery organization that focused not simply on...
But it wasn't a religion at the time he joined it. And as Justice Watford points out, he didn't adhere to that religion. And your colleague talked about the free association of religious adherents. How can you get around the fact that Mr. Decker did not freely associate with this religion?
With respect, Your Honor, there are a number of lower court cases holding that one can be a minister within an organization because that determination is based upon their promoting the message and mission of the religion without being a member of that religion. For example, in Laval, the Third Circuit held that a person who worked for a religious ministerial organization that dealt with working in third world countries and was crucial to organizing and leading and working with the missionaries in these specific countries was a ministerial employee because they were constantly purveying that message both around the world and providing the ministers with counseling on how to deal with.
So are you saying that being a member is synonymous with believing or being an adherent? Or do you recognize those two as being different things? Because your answer would seems to just sort of collapse the two. And I wonder if that's what you mean to do.
Being a member as in being a friend of Sheila or a follower of the religion as opposed to being a minister, is that the distinction you're drawing out? Or?
I think Judge Watford started out by saying, how can, is it possible for somebody to be a minister when they're not an adherent to the message? That is, they are out maybe speaking the words, but they don't hold that belief.
Yes, it is possible, and this goes back to the court's focus in Hosanna Tabor that who is a minister is about promoting the message and mission, the religious message and mission of that organization. And so if you have been hired to promote the message and the mission of that organization, whether or not you hold that belief, you can still be a minister.
He was hired to manage the organization.
He was hired to be the leader of Halcyon Springs, one of the foremost Halcyon and largest Halcyon institutions in the state of Lile. He had sort of three primary purposes that established that he's a minister. He both, helped develop Halcyon doctrine. He spoke and communicated Halcyon's message, talking about commune with a higher power, both externally as a spokesperson to the outside world and internally at weekly gatherings where he invoked the higher power.
But he didn't hold himself out as a minister, right?
That is true,
and
yes.
Halcyon didn't hold him out as a minister, right?
With respect, Your Honor, we would contest that Halcyon did hold him out as a minister. Halcyon doesn't use the term minister, they use the term technician. And as Justices Alito and Kagan reminded this court last term in Hosanna Tabor, minister is a Judeo-Christian Western word, and so you need to look at the functions and the operations that this person engaged in. And actually the third point I had to your colleague's question was that he also ministered and gave pastoral direction to individual Halcyon members for up to a third of his time in these tune-up sessions. Now, the Catholic Church may call it confession, and Halcyon may use terms like tune-up sessions and technicians rather than priest, but that doesn't mean that they're not holding him out as a minister.
I guess, again, just going back to what I asked your colleague, those people were charged for those individual sessions up to thousands of dollars per session. It sounded to me what he was doing was very similar to the kind of practice he had before he joined Halcyon.
My apologies. 2 points to that, Your Honor. First of all, when he joined Halcyon, he knew that this was not a normal recovery organization, that everything about this organization was working in commune with a higher power, and that addiction was not simply addiction to alcohol, but was ridding yourself of negativity and sin, in effect, and cleansing your whole body. And as my colleague outlined, sort of the financing structure of religions can be very diverse. For example, the Mormon Church uses tithing to fund their missionary work. The Church of Scientology in its early days did use sales of products and those sort of things to promote their work. And there was a time where the Catholic Church also charged great amounts to get confession with your bishop and financed in those forms. And so the historical nature of how this church has chosen to finance itself and how it promotes that missionary work doesn't determine that he's not a minister. And in addition...
Well, doesn't Mr. Decker's own words, though, belie the fact that he didn't view this as a religion nor himself as a minister? Because he said, had this... if this were to have been a religious matter, I would not have been a part of it. Something to that effect.
With respect, Your Honor, that certainly cuts against us. But as Starkman held with respect to a church minister, church choir director, one doesn't need to know that they're a minister in order to be a minister. And further, the inquiry is looking at the religion and the religious organization and the role you held, not whether or not you believed that role was ministerial or not. So, the court did consider that as a factor in Hosanna Tabor, but it was one factor for this all things considered inquiry. And while it's not present here, we believe those other factors the court outlined are present, in addition to Mr. Decker's important role.
Well, I don't think any of the other factors is present, besides maybe that he assisted in getting the message out. He didn't go through any religious training like the minister in Hosanna Tabor did he?
With respect, Your Honor, the record is quite clear at 30 and 35 that he did go through training. All technicians received training and certification from Halcyon, and at 35 he was hired to be the chief technician. He received that same training from Halcyon. Now, well, the
Religious training?
yeah, training in, the teachings of Sheila Davidson and how to, teach people to be in commune with a higher power. Everything about Halcyon is in the teachings of Sheila Davidson, this focus on both commune with a higher power and cleansing oneself from negativity. And so you would be trained how to engage in those interactions, how to engage in these tune-ups.
And he was formally commissioned as a technician? Is there something?
By Halcyon. Yeah, again, the record at 33 is clear that all technicians are certified by Halcyon. Unlike the Missouri, Unlike the Missouri Synod, which Miss Parrish underwent, I believe it was a couple years worth of training, Halcyon, being a newer religion, didn't have that established sort of long-standing practice, but they did have a certification procedure that's clear in the record at 33.
I want to ask, though, getting to the ultimate issue, how is our deciding this purely contract issue, how would that cause us to become entangled in religious doctrine such that it would violate the teachings of the First Amendment or Hosanna Tabor?
Answering this breach of contract question both violates the ministerial exception and the church autonomy doctrine.
How?
And the church autonomy doctrine does not require Mr. Decker to be a minister. I'd like to make that point at the outset. A determination that Mr. Decker was wrongfully fired requires first deciding that he was adhering to the policies of Halcyon and he was fit to be a minister of the Halcyon faith. That is to say, Mr. Singer, who is Halcyon within their hierarchical structure, the leader that makes these determinations, his determination to terminate Mr. Decker was in fact wrong. And Mr. Decker is fit to continue leading weekly gatherings and these other things. So that's the first determination this court would have to make under the breach of contract. And the reason the ecclesiastical abstention doctrine prohibits that is that this court has to decide between conflicting views of what Halcyon's policies, the tenets of the Halcyon faith are, and side with Mr. Decker before they can rule for him in a breach of contract claim.
What about the fact that at the time the contract was signed with Mr. Decker in 2003, Halcyon was not a religious organization, was not even trying to be one?
With respect, Your Honor, we submit, as my colleague has argued, that Halcyon was a religious organization from its inception. However, were this court to determine that it became a religious organization at some later time, the for-cause language in the contract, Halcyon's policies, incorporates the core tenets and teachings of Sheila Davidson. Those are the 10 points that Mr. Decker and all other members had to sign. Those are, the 12-step program and going through that. And so needs to be a dynamic interpretation of that Halcyon's policies, that when he signed the contract, the policies were such, and we believe that they made it a religion, but perhaps the change in policies and change in the teachings of Sheila Davidson made it a religion later. Still, at the point of his termination, those policies have to incorporate this change. If you think about a Congregationalist church that doesn't have any hierarchy, it's one parish.
If it was already a religion in 2003, why does the memo, the 2007 memo, the subject line is Halcyon's ascension from recovery organization to world religion? It was a recovery organization in Halcyon's own view, it seems.
With respect, Your Honor, clearly the title of the memo is not cutting or does not make Mr. Singer look particularly good in this case. However, if you look at the substance of the memo, it's focused on gaining the legal rights that it has as a religion. The memo doesn't suggest we're now going to convert into being a religion. We're going to let the world recognize our religious faith and let the government give us the accoutrements that come along with being a religion, the legal entitlements.
If the world was to recognize, if the purpose was to let the world recognize Halcyon's religious faith, why was the memo to be confidential?
With respect, Your Honor, there were certain legal steps and other organizational steps that needed to be rolled out, and this is a very hierarchical church. And prior to sort of putting out a big encyclical to the followers, Mr. Singer wanted to figure out the internal organizational steps. I know within the Catholic Church, the Holy Father does a lot of internal discussion and running his encyclicals by many cardinals, etc., before publishing it and announcing it to the outside world. That was an early stage determination by Mr. Singer about seeking these legal entitlements, and they had not chosen how to publicly convey that both to the followers and what steps they needed to take with respect to the government to get those legal entitlements.
You want us to extend the ministerial exception to breach of contracts, right?
We would like you to extend the ministerial exception to the breach of contract if it requires, if the contract is a for-cause firing for religious reasons.
And that's totally inconsistent with the holding in Hosanna Tabor, because the court there made very clear that the firing did not have to be for religious reasons, right?
Yes, and what actually distinguishes that is the ministerial exception is protecting that ministerial relationship between a minister and their church from government intrusion. And that's why Title VII and sort of none of these employment laws can reach in and get in between that relationship. However, if the minister and the church have settled rules and regulations for that relationship, the government isn't externally legislating with respect to that. They are laying down their own rules to comport by. And so it's only when you come into court with those rules, and those rules require religious determination, that it would be a problem. So, you know, the ministerial exception is centrally focused on that relationship, and the legislative actions and sort of Title VII and those regulations are why the court made clear you don't need a religious reason not to apply Title VII.
So you would say then that the ecclesiastical abstention doctrine, I think is as you called it, basically just collapses into the ministerial exception in the breach of contract context?
Except that the ecclesiastical abstention doctrine also deals with contracts that are not related to a minister.
There's no work for the ministerial exception to be done in the breach of contract context. You would say it's just subsumed by the ecclesiastical.
So we would actually suggest that the ministerial exception does give something of a life valve in ministerial situations where the contract has not specified. So here they chose to bind themselves with certain for-cause terms, but where a contract hasn't specified what the firing is, if that person is a minister, obviously the court shouldn't come and put them back into position and shouldn't require a court to pay them as if their rightful position was to continue being a minister. So it applies in, I guess it adds a safety valve for when the contract hasn't specified, but that's not an issue in this case. We have the for-cause firing provision, and we have Mr. Singer's declaration that Mr. Decker violated Halcyon's policies, violated the tenets of its faith.
So you would say that if the reason for the firing, let's say, were that Mr. Decker brought a weapon into the workplace in violation of one of the specific clauses of the contract, then it would be perfectly fine for the court to adjudicate that dispute?
Yes, absolutely, we would agree. And in fact, in Castillo, the D.C. Circuit found that certain contracts between a Catholic organization and some Catholic bookstores could violate the Sherman Act and certain antitrust acts because there was no Catholic rationale for this contract to collude to raise the prices of a few specific books by the Holy Father. And so, you know, we think that not only breach of contract, but other statutory provisions can apply in those cases. And so in your hypothetical, we would.
So can you give us then an example of a provision that I suppose that would be one of the well, I guess that's the example that Justice Watford just gave you. But in looking at the example in this case, why do you say that causes us to make a doctrinal determination of whether this conduct is violative of the contract, such that, you know, we should not delve into it?
With respect, Your Honor, I see that I'm out of time. May I have leave to answer your question?
Sure.
So the violation of Halcyon's policies and being unfit to be a minister of the Halcyon faith are the proffered reasons in the record at 38 and the record at 48 for this firing. And for the court to determine this case, the first thing they have to ask is Mr. Singer's proffered reasons and his belief about Halcyon's policies, are those the true belief about Halcyon's policies? And was Mr. Decker's action in violation of those? Or is Mr. Decker, when he went on Oprah and made statements that cut against the Ascension Memo and made statements that cut against some of Mr. Singer's policies, are those the true policies of the Halcyon faith? And it's that determination that the ecclesiastical abstention doctrine prohibits this court from engaging in.
Thank you.
May I have leave to make our prayer for relief?
Sure. For
the foregoing reasons, this Petitioner Halcyon asked this court to reverse the Supreme Court of Lile. Thank you.
Counsel?
Thank you, Madam Chief Justice, and may it please the court. My name is Lyle Kosis, and along with my co-counsel, Archith Ramkumar, represent the respondent, Alan Decker. I will be addressing the first two issues in today's case, which is whether Halcyon is a religion and Alan Decker is a minister for purposes of the First Amendment. Your Honors, this case is about setting the right incentives when seeking religious or ministerial status under the First Amendment. Therefore, this court should uphold the judgment of the Supreme Court of Lile for three main reasons. First, there is no state action in this case sufficient to trigger the First Amendment. Second, Halcyon is not a religion for purposes of the First Amendment. And third, Alan Decker is not a minister for purposes of the ministerial exception to the First Amendment.
So why don't you just start with the state? I don't understand the state action argument at all, so help me with that. We have cases in which there are two private parties involved. These church property disputes are a perfect example in which the only arguable state action was just a court trying to resolve the dispute, and the Supreme Court has said that can violate the First Amendment. So what's the problem here?
Well, respectfully, Your Honor, Respondent believes that the cases have never affirmatively stated that there is state action sufficient to trigger the First Amendment in those instances.
Well, let's take Jones versus Wolf.
Sure.
The only thing the Illinois Supreme Court did was to say that the action of whatever that church's tribunal was arbitrary and capricious. And there was no other involvement of the state whatsoever other than the Illinois Supreme Court announcing that rule. So how could that? Seems to me we've got the same situation here.
Well, the first response, Your Honor, is that the logic of the criticism against Shelley is strong and should apply in this instance. And if the court didn't wrestle with it at that time, Respondent would push the court to wrestle with it at this time.
No, I'm saying we've already done that. We have all of these cases that we've decided in which the only state action was a lower state court trying to resolve a dispute. There's no positive law involved. There was no government agency as a party. There were just private parties involved. And we've nonetheless held that the lower court's attempt to resolve the dispute violated the First Amendment. There's nothing more that was required.
Well, the only thing I would say, Your Honor, is that in Jones versus Wolf, if I remember correctly, that was also a product of the ecclesiastical abstention doctrine, if I remember. And Respondent would necessarily contend that that isn't so much a product of the First Amendment, but just an abstention doctrine. And like Younger abstention and like Burford abstention and other abstention doctrines, those are not based on constitutional principles, but merely the recognition by this court and other courts that it is not institutionally competent to handle these claims. It's not so much the court saying that we have state action in violation of the First Amendment, but that we are going to abstain from making a decision which requires us to...
I think if you go back and look at those cases, they say very clearly that the action of the court violates the First Amendment. That's the grounding. In fact, that's the only basis on which the court would have had jurisdiction to hear a case coming from the state court system.
Well, to the extent this court wants to accept that reading, Your Honor, Respondent would still maintain that Halcyon is not a religion to satisfy, for purposes of satisfying the First Amendment. And the first reason it is not a religion is because it doesn't satisfy the first factor of the Africa test. Now that factor...
We're certainly not bound to adopt that test.
Absolutely right, Your Honor. But the reason the first factor in that test is necessary is because it gets at the core and the unique province that has occupied religion throughout time. And it is questions such as the afterlife, such as the origins of man's nature, and issues concerning the relationship between man and his creator that have been at the central core of religion. Now, importantly...
If we determine, though, that Halcyon is not a religion, or it's not a religious group, don't we risk favoring some religious groups over others, establishing a prohibitive priority within religious organizations?
Respectfully, no, Your Honor, and that's true because the test Respondent proposes, modeled after the three factors in Africa, doesn't scrutinize the substance of the answers provided by these alleged religions. For example, these factors don't say that to be a religion you have to supply answers that are similar to the Judeo-Christian religions. If someone wants to believe that there isn't an afterlife or that there is an afterlife not like the Christian religion's afterlife, that is perfectly acceptable under this test. All the test asks is that the alleged religions just address those questions. How they answer them is beyond the scrutiny of this court, and Respondent believes that that is the correct answer under this court's current doctrine.
So why isn't belief in a higher power sufficient?
Well, it's not sufficient for a number of reasons, Your Honor. The first reason is because Halcyon has not clarified whatsoever what exactly this higher power is. And without understanding what it is, it's impossible for this court to know if it actually touches on these areas of ultimate concern that have been at the core of the first factor outlined in Africa. Moreover, Your Honors, as Mrs. Chief Justice Donald noted in the previous argument, this court should be concerned with setting the right incentives so that not everybody becomes a religion. If merely expressing a belief in a higher power is enough, without supplying anything more, then it's going to be very difficult to actually say someone is not a religion, because it is so easy to come forth and say, I believe in a higher power and nothing else. In addition to the higher power not being sufficient, Your Honors, Respondent also points this court to the fact that Halcyon doesn't address other common ultimate questions, such as whether or not there is an afterlife and what the origins of man are, or the origins of people in general. Those are just a few of the factors illustrated in the record that highlight how Halcyon cannot pass the first factor in Respondent's proposed test. Now, the second factor looks at the comprehensiveness of the religion. Halcyon is not comprehensive. For example, the record at 29 notes that Sheila Davidson gave talks during her life focused on addiction-free living. That highlights that the organization was focused on recovering from the addiction of external negative influences. Moreover, the record at 32 highlights the membership agreement that Halcyon had members sign. And that membership agreement on the record at 32 states, quote, I believe and rely on a higher power which enables me to live in an ever-expanding state of recovery from addiction, illness, and negativity.
Well, the Ninth Circuit has found, at least the Ninth Circuit has found, that AA itself is sufficiently religious to qualify for First Amendment protection. So why not Halcyon? Certainly Halcyon's going above and beyond what AA does.
Well, I'm not exactly sure of which case Your Honor is referencing, but...
It's Kimna.
Well, to that extent, Your Honor, there's some discrepancy in the Ninth Circuit and possibly the Second Circuit as to whether there is a separate definition of religion for Establishment Clause purposes. Some courts believe that there is a separate definition and that it is an exceptionally low bar. Respondent believes that approach is inadvisable and that there should be one unitary definition of religion for both the Free Exercise and Establishment Clause cases. And under that approach, adopting something similar to the three-factor test proposed by Respondent, it would hold that both Alcoholics Anonymous and Halcyon is not a religion under that test.
Well, Counsel, I agree with you that there should be one unified test, but I mean, I think of our precedent, let's say in a case like Seeger, where the views expressed by the folks there who were granted a conscientious objector status weren't very much more comprehensive or all-encompassing than the views of these Halcyon followers. So maybe you could address that case.
Sure, Your Honor. Well, Respondent has two responses to the Seeger and Welsh decisions. The first is that they were interpreting religion, or excuse me, the relation of a belief to a supreme being in the statutory context, the Uniform Code of Military Justice. So Respondent believes, one, that they have less relevance when establishing the constitutional definition of religion. But more to Your Honor's point is the fact that Seeger and Welsh were wrestling with whether an individual's belief on its own was sufficiently religious. And that is an entirely different question from whether an organization or a group or a belief system is religious. And it can be illustrated by noting that this court would never say, does an individual have the accoutrements of religion? But this court should and could say, does an organization have the accoutrements? And that explains why Seeger and Welsh don't answer the question for this court and why they should not be considered controlling in this case. Now, in addition to not being comprehensive, Halcyon also doesn't satisfy the third factor in the Africa test, which focuses on the presence of certain formal or external signs or religious accoutrements. Halcyon only has two traditional accoutrements. They have a founder and they have followers. They do not, however, have many of the other traditional accoutrements of a religion: worship services, rituals, holidays.
Well, they meet every Sunday, at which there is music, singing, a time for communion. Someone gives a lecture or a sermon, and there's a call at the end to come forward and time for prayer to the higher power. That certainly sounds like all the accoutrements of a traditional religion as one would understand it.
Well, Respondent would respectfully disagree, Your Honor, for two reasons. The first reason is that these worship services, to the extent they are that, look a lot more like just basic meetings where people sit together to talk about addiction. But to your second Honor's point as far as the communion goes, the record does not state that there is communion as it relates to the higher power. The individuals are just encouraged to engage in a few moments of silence so they can engage in communion. But as the record of 38 makes clear, individuals at Halcyon maintain their traditional faith in their other religions, such as Christianity, Islam, and Judaism. For example, To the extent anyone is communing at those halcyon services, it's not clear they're even communing with the higher power as halcyon understands it, or their own higher power as it relates to their traditional religion.
Well, how would they demonstrate in any other religion that they're communing with the higher power, whether it's, Western Christianity, Buddhism, Catholicism? How is that manifested?
Well,
so
Your
clearly
Honors,
that you can say they're not communing with the higher power here when they are meditating or having a moment of silence.
Well, Your Honor's example, Respondent believes it will be different because in the religions Your Honor suggested, there is some content, some unique definition of this higher power, whether it be the Christian God, the Jewish God, etc. And there is more content in that instance than in the halcyon instance. Additionally, those religions, as best Respondent can understand them, do call for express prayer directed toward those specific supreme beings. That explicit directive is not clear from the halcyon materials before this court, again because the Record of 38 makes note that many members of halcyon have maintain their faith in their traditional religions.
Well, let's say that we disagree with you about whether halcyon is a religion. Are you also going to address whether Mr. Decker is a minister or not?
Well, absolutely, Your Honor. And because halcyon can't satisfy the third accoutrements factor, it should not be a religion. But to Your Honor's point, absolutely. Well, to Your Honor's point, Alan Decker is not a minister because he doesn't satisfy the four-factor test outlined by this court in Hosanna Tabor. Again,
well, I don't think we purported to announce a four-factor test. We, in fact, I think said it's too early for us to announce any kind of a rigid test. Here are considerations that we think are relevant here, and in light of those, here's the outcome. But I don't think we set up any kind of a rigid four-factor test.
Well, Respondent doesn't propose that this is the only four-factor test this court could ever use. But given the recency of the Hosanna Tabor opinion and the fact that the majority opinion outlined these are very four relevant factors, Respondent thinks it's the best guide for this court to use in this situation. And the reason for that is because those factors provide this court with concrete guidance as to who is and who is not a minister.
Okay, so you heard your opponent say that, in fact, at least three of those four factors are met here, that Mr. Decker did receive religious training, right? He was formally certified as a technician, right?
Well, respectfully, Your Honor, the Record of 31 says that technicians undergo some type of certification, but the record isn't clear as to what Alan Decker himself did, especially because he was one of the first technicians brought on. So it's not clear that that formal certification process even applied to him because he was brought on so early in this process. But even if he was formally certified, Justice Watford, it's not clear what that even entails. Did that entail religious classes or religious training, or the need to demonstrate religious knowledge before a group of representatives from Halcyon? Moreover, the other factors mentioned as important by this court in Hosanna Tabor also are not met in this instance. One of those factors this court mentioned, and which Respondent believes should apply in nearly all circumstances, is how the institution views the individual. Here, Halcyon viewed Alan Decker as secular. It gave him a secular job title, assigned him to work at a secluded luxury resort, and tied his bonuses to revenues, not religious performance.
Yeah, but you have to concede that he was getting the message of the religion out to the followers, right?
Well, respectfully, Your Honor, it's not clear that he was doing that because the Record of 37 states that Alan Decker never thought he was a particularly religious man. So it's not clear that what
okay, but I mean, I was persuaded by your opponent's argument that you don't necessarily have to be a true believer to be a minister, as long as a central part of your duties is getting out the message of the religious organization. It seems to me that's what he was doing here, no?
Well, to the extent he was doing that, Your Honor, it still wouldn't be able to overcome the fact that he didn't think he was a minister, that he didn't have the religious or education training that is normally associated with a religious minister, and it could not overcome, again, that Halcyon still viewed Decker as secular, even to the extent he might have been communicating the message of Halcyon. It's still, sorry.
Complete your answer to that, and then I have a question.
Sure, Your Honor. It still cannot overcome the fact that based on his contract and his job title and where they assigned him to work, those are compelling objective factors this court should look at in ruling that Halcyon thought Alan Decker was a secular employee.
Okay, you mentioned objective factors. And what weight, if any, should we give the Ascension Memo and Halcyon's sincerity in determining whether or not it's a religious entity? The language that they used in the memo, the fact that it appeared that they converted at one point from strictly a recovery organization to a more religious than secular organization. How should we consider that? How should we evaluate it?
It's difficult, Your Honor. As Your Honor mentioned, this is questionable timing in this case because they seem to be seeking this type of religious exempt status as just a means to encourage or help their enterprise. Respondent is not exactly sure how this court should weigh that, and Respondent does not outright question the sincerity of Halcyon. But admittedly, the tax treatments that are mentioned in the Ascension memo and the timing of the memo itself do present this court, or should present this court, with some pause in actually stating that Halcyon is a religious institution. But the fact that Halcyon should not be viewed as a religious institution underscores the fact that Alan Decker, again, is not a minister. One of the most important factors this court, not the most important, but one of the other important factors this court highlighted was how the individual viewed himself. And the record of 33 to 34 makes that clear, that Alan Decker never thought he was actually a minister. And
why does it matter what the individual thinks as opposed to what the organization thinks? And here it seems very clear, given how the firing went down, that the organization viewed his attempt to get the message out as being inconsistent with the message that the organization wanted to deliver, at least what he said on the Oprah Winfrey show. So why isn't that the most important consideration?
Well, to the extent I misspoke, Your Honor, I want to say it's not the most important consideration, but Respondent believes how the individual views himself and how the institution views him are both probably the two most important considerations for this court to undertake. Admittedly, Your Honor, I see my time's expired. May I have leave to conclude answering?
Well, maybe if you could just answer. I agree with you that what the organization thinks is one of the most critical, but here it seems like the organization very clearly did view him as having a role in getting the message out, and that's why he was fired, because he started to speak off message.
Again, Your Honor, his employment contract with the organization, where they stationed him to work, and the fact that they started using the word minister without ever switching his job title, in Respondent's view, is compelling objective evidence it actually never viewed him, in fact, as a minister. For the foregoing reasons, Respondent respectfully requests that this court affirm the judgment below. Thank you.
Thank you, Mr. Persis.
Madam Chief Justice, and may it please the court, my name is Archit Ramkumar, and along with my co-counsel Lile Kosis, represent Respondent Alan Decker. I will be addressing the second issue today, which is whether this court can adjudicate a breach of contract dispute between a religious organization and a ministerial or other employee. Your Honors, today's case is about basic contract law. Even if Halcyon can demonstrate that it is a religion and prove that Alan Decker is a minister, this court can still adjudicate Alan Decker's breach of contract claim for three main reasons. First, breach of contract claims are fundamentally different than anti-discrimination lawsuits. Second, there are sound practical reasons for this court to adjudicate claims like Alan Decker's. Last, adjudicating such claims complies with the Establishment Clause.
Okay, so let's go back to the first. The rationale that we articulated in Hosanna Tabor for the ministerial exception, at least, seems to me to knock out your first point. Because there we said the reason the court can't adjudicate even the dispute in the anti-discrimination context is because it would require a court to say that the reasons the organization gave for firing the person were wrong. It seems to me that in order for us to rule in favor of your client here, that's exactly what a court would have to do.
Two responses to that point, Justice Watford. First, that sentence that Your Honor just described began with the word "such relief," suggesting that this court still viewed the relief being sought by Cheryl Parrish in that case as critical. And second, this was further reinforced when this court outlined what it considered two core considerations behind the ministerial exception: not forcing a church to accept or retain an unwanted minister, and not punishing a church for doing so. Compensatory damages, the remedy for contract claims, do not offend either core aim.
You think that the entire decision in Hosanna Tabor turned on the fact that the plaintiff there was seeking punitive damages?
Respectfully, Your Honor, first, Cheryl Parrish was seeking front pay in lieu of reinstatement, back pay, attorney's fees, and punitive damages. But second, the way Respondent does read this court's decision in Hosanna Tabor, the type of relief being sought was critical to the court's decision in that particular case.
I guess what I'm suggesting to you is that the fact that she sought punitive damages had nothing to do with the outcome. And are you making a contrary argument?
Respectfully, Your Honor, Respondent only points to this court's language that churches cannot be punished for their decision, and the contract and tort law distinction between damages that punish punitive damages and damages that do not punish compensatory damages.
So if we remanded this case on the breach of contract claim, in order to make determination, wouldn't the court have to, of necessity, get involved in an internal religious matter in determining whether or not the contract was or was not breached?
Respectfully, Respondent disagrees, Your Honor. First, the contract in this case is entirely secular in nature. There is not a single conclusively religious provision. Second, more importantly, at this stage in the proceedings on a motion for summary judgment, drawing all inferences in favor of the non-moving party, there is a compelling secular reason for Alan Decker's firing. The record at 34 indicates that Paul Singer viewed Alan Decker as a threat to his control of the company. And the record at 37 indicates that many friends of Sheila renewed their calls for Singer to be replaced by Decker after the Ascension memo.
But the timing of the firing seems to be linked directly to what your client said on the Oprah Winfrey Show, which was deemed very inconsistent with the message the organization was trying to get out.
Again, Your Honor, Respondent would point to that as one piece of evidence as to what Paul Singer might have thought, but drawing all reasonable inferences in favor of the non-moving party Respondent, there is also a good secular reason for his firing, at the very least for this court to let this claim go forward.
But wouldn't you have to, I mean, isn't there evidence that could be, could construe this as secular, and then some that could construe it as religious, and wouldn't you have to make a determination as to what it was and get into some of that internal doctrinal message that we've talked about?
Well, respectfully, Your Honor, Respondent would submit that this court would not have to determine Halcyon's determinations of their internal faith because, again, Alan Decker has an opportunity to show that the reasons for his firing were secular. Now,
Well, the reasons for his firing are clearly listed in the record in the December 3rd, 2007 termination letter. It says, "You are no longer fit to minister the Halcyon way of life." And so to Justice Donald's question, that would necessarily entangle us in the debate amongst the Halcyon members as to their doctrine or way of life, wouldn't it?
Well, importantly, Your Honor, that was what Paul Singer said, but the contract that governed the relationship between these two parties was entirely secular in nature. And again, this is one piece of evidence being put forth by Paul Singer, but at this stage in the proceedings, it is not clear that a conclusively religious determination is necessary. Going forward, if a conclusively religious reason appeared, if Halcyon produced internal communications reinforcing this, for example, then the district court judge could dismiss the suit if and when those concerns arose. But importantly, Respondent submits to this court that at this point in time, those concerns are not present, the excessive entanglement that Petitioner discusses. Now, the second principal way contracts differ from anti-discrimination claims is they are entirely voluntary in nature. This underscores two important points. The first is that Halcyon had complete control over the language it placed in the contract.
Yeah, but they've conceded that point. They just conceded it, in fact, this afternoon. I mean, I don't think there's any dispute now. They're saying that, yeah, if it was a purely secular provision, sure, you could pursue a breach of contract claim for that. They're just saying that the good cause provision here also encompassed fitness to continue serving as a minister, and that's the basis on which they discharged him.
Two responses to that point, Your Honor. First, using a justum generis, the contract must be interpreted with a secular meaning. And second, Halcyon, if it truly wanted to avoid judicial review, could have made itself clear, like the contract at issue in the Friedlander case cited in Respondent's brief. It could have placed a clause in the contract implicating religious duties.
Well, the contract, I'm just looking at this last phrase. If it says he can be discharged if Halcyon reasonably determines that the employee is unfit to remain as an employee. Now here, if we find that he was a minister, it expressly says here that they get to determine whether he continues to be fit to serve as a minister. And they're saying that no, he wasn't, given what he said on the Oprah Winfrey Show.
Respectfully, Your Honor, Respondent would again point to the fact that that clause is preceded by 6 different secular clauses, and consequently the contract has to be construed with a secular meaning until Halcyon comes forward with a conclusively religious justification for its firing of Alan Decker. And here, Halcyon at any point could have placed language making it a conclusively religious contract like the plaintiff.
Their religious justification is that he is no longer fit to minister the Halcyon way of life. That's their religious justification. Go ahead.
Yeah, respectfully, Your Honor, Respondent would again label that as one piece of evidence offered by Paul Singer, but
Why isn't that enough?
because, Your Honor, this court is hearing this case on a motion for summary judgment and drawing all inferences in favor of the non-moving party, Alan Decker. There is a compelling secular reason, as Respondent has illustrated, for his firing in this particular case. As such, this court must remand and allow this case to pursue further. Now, Halcyon could have conclusively shielded itself from judicial review by placing a clause in the contract indicating religious duties, or alternatively, submitting this dispute to some kind of internal judicatory body. And here, Respondent wants to make an important point. The ecclesiastical abstention doctrine is a limited abstention doctrine that applies to decisions by ecclesiastical tribunals and issues of canon law. It does not, however, apply to decisions of the sort here, where it is not clear at all that Halcyon ever established any kind of internal judicatory body that it submitted disputes to for an internal process where courts and ecclesiastical tribunal decided disputes. Now, the second reason that this court should affirm the Supreme Court of Lile is there are sound practical reasons for this court to adjudicate claims like Alan Decker's. Chief among them is setting meaningful limits on the ministerial exception. The exception is a highly circumscribed doctrine, and as Respondent notes in its brief, it does not even bar all claims brought by ministers.
Yeah, and they're conceding that in the breach of contract context. They say there's all sorts of breaches that could be adjudicated, so they're not disputing that.
Yes, Your Honor. Respondent only uses this to make the further point that here, because the contract is entirely secular and has to be given a secular meaning given contractual interpretation principles, if this court held that the ministerial exception barred such a claim, it would be a short step to then allow the exception to bar claims by a contract between a third party and a religious organization. Second, as Respondent noted at the beginning of its presentation, the question before this court is whether this court can adjudicate a breach of contract dispute between a religious organization and a ministerial or other employee. Were this court to accept Petitioner's proposition, the ministerial exception would then operate to have no bounds. It could then be expended to employees who are not ministers and then subsequently third parties. And at that point, churches would be above the law, which they are not. Now, second...
Well, let's just say that we don't accept your reading of this contract as being purely secular. Do you lose in that scenario?
Respectfully, Your Honor, Respondent would disagree because, again, Respondent would submit that there's still not conclusive religious proof behind Alan Decker's firing, drawing all inferences.
Let's just say that we don't agree with your reading of this contract as being purely secular. Okay, so I'm looking at this phrase that says whether he's unfit to continue to serve as a minister. That seems to me to encompass religious-based reasons for firing, and that's what we've got here. So if that's how I interpret the contract, is there some other way that you think you can still prevail?
Simply, Your Honor, insofar as Respondent would suggest that even if the contract was interpreted as potentially encompassing religious functions, Halcyon has not conclusively shown that that particular reasoning governed the decision here, again, because of the evidence that Respondent has on its side for its decision. Now, importantly,
I'm still not quite clear where you come down. You were suggesting that Halcyon could have protected itself by putting in a clause that specifically referenced religious duty, right?
Yes, Your Honor.
So I'm saying, let's say that I interpret this last clause in this contract as encompassing that. Do you lose, or is there some other way you can still win?
So if I understand Your Honor's hypothetical, would Your Honor be interpreting the clause then as conclusively religious and not possibly religious?
Well, I'm not talking about the actual reason given. I'm just saying that the contract would allow for a firing if they determined that, hey, pal, the message you've been articulating is inconsistent with what we think needs to be put out there. And if that's covered by the contract, right, then it seems to me that we're squarely in the circumstance that you said would put you out of court. And I'm just trying to make sure, is there any daylight there that I'm missing?
Your Honor, Respondent would merely attempt to posit a distinction between provisions that are conclusively religious, such as the phrase rabbinical duties, for example, and conclusions that could be religious down the line. And that has an important consequence because, as Respondent notes in its brief, district court judges have the opportunity to manage cases, and if and when conclusively religious reasons appear down the line, they can then dismiss the case.
But okay, I hear what you're saying. That makes sense. But don't we have, at least from the churches or from Halcyon's standpoint, don't we have conclusively religious reasons? They're saying that you're no longer fit to minister to the faithful.
And, Your Honor, Respondent's point on this is, again, simply that is one piece of evidence offered by Paul Singer, but Alan Decker, the non-moving party, has a secular justification for his firing.
So are you saying they would be required to articulate the components of that unfitness or non-fitness? Is that what you're saying? That just to say that you're no longer fit, that's not sufficient?
Respectfully, no, Your Honor, that is not what Respondent is saying. As Respondent noted in its brief, churches have very good reasons for wanting contracts enforced in civil court, namely offering talented individuals contractual job assurance. Thus, Respondent's point is simply that if churches want to avoid judicial review, they have to be clear in the contract about doing that. And in Respondent's view, Halcyon was not sufficiently clear to warrant protection under the First Amendment. Now, the last point is this court should affirm the Supreme Court of Lile because doing so complies with the Establishment Clause. District court judges are in the best position to manage cases, and if and when, Your Honor, I see that my time is up. May I have leave to finish?
You may finish your sentence and your prayer.
District court judges can dismiss the suits if and when religious concerns arise. For the foregoing reasons, Respondent urges affirmance of the Supreme Court of Lile.
Thank you, sir. Petitioners may now make their rebuttal for 3 minutes.
I'd like to make 2 points and 1 clarification on rebuttal. First, respondents are asking that you interpret this organization because it has a wellness and sort of health mission to be non-religious. However, Yoder makes clear that you can have a recovery organization that's secular and a recovery organization that is religious. And it's the religious mission and message within that organization that make it so. And the cases we've cited in our brief dealing with Alcoholics Anonymous make precisely this point. In fact, if you flip the inquiry, these Alcoholics Anonymous cases say the prison or another organization cannot order someone to go to AA because it is religious. That violates establishment. And so you need to ask, could a court order someone to go to Halcyon and engage in tune-up sessions and engage in commune with the higher power in order to recover from negativity and sin and all of these other things in their life? Or would that violate the Establishment Clause? We submit that would violate the Establishment Clause. And so to not give Halcyon the ministerial exception is to treat it as a second-class religion. No, the government can't force people to go engage in your teachings.
How should we rule if we find that Halcyon is a religion, but Mr. Decker was not a minister?
If Mr. Decker is not a minister, you still come back to the issue of a for-cause firing when you have a for-cause religious determination at issue. And again, this goes to ecclesiastical abstention. If the reasons that we have proffered are religious, the court cannot inquire into that. Contrary to respondent suggestions, finding or holding that all inferences cut in Mr. Decker's favor is to say that this proffered reason is not a religious reason. And you can't make that inference.
They're saying that it's pretextual and that the real reason was this struggle for control of the future of the organization.
2 points.
They're not questioning the religious nature of the proffered reason. They're just saying that wasn't the real reason for the firing.
2 points with respect to that, Your Honor. First, as the First Circuit held in Nadal in 1989, in a similar dispute between two individuals claiming to be head of the Russian Orthodox diocese there, that kind of determination over who has the power is essentially an ecclesiastical determination. The court said, quote, "It is impossible to disentangle the leader of this religious organization from the religious mission and the tenets of this faith." So we would submit that that clearly is at issue here, and that, this proffered religious reason, whether or not, Mr. Singer should be the leader or Mr. Decker should be the leader, Mr. Singer has authority. And to say that this is a power struggle is to say that they have a dispute over Halcyon's tenets and over who should lead this church. Much like if people left the recent conclave suggesting that Cardinal Wuerl would be a better pope than the Holy Father Francis. Third, the ecclesiastical abstention doctrine does not simply apply to determinations by religious review bodies. This court in Gonzales held that it couldn't review a will that requested someone be given the Bishop of Manila at that time within the Catholic Church, because it would have to decide whether or not this will could give that authority or whether or not the bishop who had previously appointed someone could give that authority. It had nothing to do with going to the canon courts. You didn't have Cardinal Burke in Rome making a determination. You just had that issue. And I see that I'm out of time. Thank you very much, Your Honors.
Thank you, all counsel, for your argument. The matter is submitted. We'll take the matter under advisement and rule in accordance with the competition guidelines very shortly. You may be seated. The court, having heard argument in the matter of Halcyon versus Decker, has deliberated and made determinations in accordance with the rules governing this competition. And we want to give you those determinations, but first we want to give you our thanks, first of all, and our commendations for your argument. And we're going to make comments first, and then I'm going to announce the court's decision. So I'm going to punish you and make you wait just a little while longer. I'm going to first turn to Justice Watford for your comments just about oral advocacy generally and anything else you want to say.
Well, let me compliment all four of you first off on the excellent performance. It's sad to say that you guys were well above the norm of what we see, at least out in my court in the Ninth Circuit. It's a real pleasure to see such well-prepared advocates. I mean, what impressed me, I guess, I'm not going to speak to you guys individually, but just globally, what impressed me is, number one, all of you did a great job, I thought, of even when you got a question that maybe wasn't geared toward your strongest points, being able to take the questions and try to not dodge them, but answer as best you could, and then immediately transition back to a point that you really wanted to get across. That's one of the toughest skills to master as an appellate advocate, because most often what happens is either, number one, you don't ever directly respond to the question that the judge puts to you because it's not really on your strong territory, and you get the judge frustrated, the judge thinks you're being evasive, or you end up getting consumed talking about stuff for that just eats up all of your time, and you don't have enough time then to get back to the strong points that are going to win you the case. I thought all of you did a great job of directly responding, answering it in a meaningful way, but then saying, but let me move to this other point. So that was terrific. The second thing I thought you guys also did really well, which might sound kind of trivial, but you actually listened to the questions and tried to respond to what the judge was asking. So what's so frustrating, I've found, just even in the short time I've been doing this, is that you'll ask a question and the advocate will just start talking about something else, and you're just, what was wrong with that? But a lot of times, and I can just speak from experience as an appellate advocate, you're up there, your mind's racing with so many things you're worried about. I got to get this point out. You're not even hearing the question, and so you're not even able to connect with the judge in terms of responding. I thought all of you guys did a terrific job of just being focused, listening to the question, and then answering it. That sounds like it should be the simplest thing for an appellate advocate to do, but let me tell you, you guys will find when you're in practice, it's one of the most difficult things. So I really thought, again, all four of you did a great job on that front. The other thing that impressed me, the last point I'll make, is all of you knew the record so well. I was so impressed by how often you were able to actually cite specific page numbers, in fact, from the record. That is, again, just a really undervalued skill, I think, among appellate advocates, because as the judges, we're going to certainly be familiar with the law. I mean, we have access to the cases. We've a lot of times have already had cases in that area and are familiar with the general law, but what we're not familiar with is the specific factual record in your case. And that is always something that you should, as an advocate, know far better than any of the judges, and you guys exemplified that. I thought that was really impressive.
Thank you, Justice Watford. Justice Tonkin. Thacker, pardon me.
First of all, I also want to commend the four of you all on making it this far and on your fabulous performances. I can certainly say that your presentations today, I could not have done when I was in law school, nor would have I even volunteered or tried to do what you all have done today when I was in law school. So you all are far ahead of the advocacy game already. I will just echo what Judge Watford said with regard to listening to the questions. One of the things when I'm giving pointers to students, one of the things, as he said, that seems simple, but that I always say is listen to the question, answer the question, and actually answer the question asked. And that, as he pointed out, just sometimes does not happen. I just last month I had an argument where, for me, and I was perhaps the only person on the panel that would have been going in this litigant's favor, there was a particular paragraph in the contract that I wanted to focus on, and I actually said, maybe I can help you. Look at this paragraph. Nobody's talked about it. Tell me what it means, because I think it goes in your favor. And he said, paragraph 8, and sort of stood there for a second and walked back to his table, which was fairly far away. I thought he was going to get paragraph 8. Goes back there and picks up a bottle of water like it's sitting there, drinks the entire thing, comes back, notably without paragraph 18, looks at me and says, and I said, okay, so my question, and he says, you know, I don't really want to talk about paragraph 18. I'm going to talk about this other paragraph. And I said, okay, then I don't really want to listen to you anymore. So it's pretty important to listen to the question and try to answer it. The other thing, again, that I thought you all did fabulously well, and probably because you were listening to questions, you were able to do this, is to transition, as Judge Watford said, back to your, you know, everybody has their 3 points, 2 or 3 points they want to make, and you all did a good job of getting back around to those while weaving the record and the case law into it quite well. Then just sort of the basic skills that all four of you have that are important. Eye contact, actually looking at the judge who asked you the question, and all the judges when you're speaking. And then your voices were clear, loud, strong, not too loud, but loud enough to command attention and cause us to pay attention to you and not, you know, not our minds not wander elsewhere. So I appreciated that as well.
Thank you, Justice Thacker. I want to adopt the comments of my colleagues and commend you on your performance. You all were wonderful. You were prepared. You were all very confident. And I think that confidence sprang from the fact that you were prepared. You knew the record, you knew the law. I know you've been through a number of rounds, you're very familiar with the problem, and I want to just stop right now and really commend and compliment the problem drafters. I don't know who you are, we'll find out later, but it was an excellent problem, and I thought it was so well done, and it was a joy to read and work with, and I can tell it was a challenging problem, but it was also, I think, a problem that was not a lopsided problem. I've seen those that are drafted, and they sort of are a little bit lopsided, and they actually go to more to one side than the other. This was not the case, and so I thought it was very well done. You all handled the materials well. You discussed important cases. If a judge brought up a case, you addressed that, and you moved on. And I want to just say something that my colleagues may disagree, but sometimes, quite candidly, the judge's questions just don't make sense.
I completely agree.
And your facial expressions did not yell, "What are you talking about?" Y'all were perfectly respectful. Your facial
No,
demeanor.
our questions made sense. It was other people. Yeah, not us.
That's right. But I think if you ever get that question that's really just sort of blathering, you all will have the poise to deal with that in a manner that, you know, just connotes respect for the bench and for the process, and that's good because you in your careers you will confront that. I guarantee you. It seems to me that you are very familiar with the fact that questions are your friends. They give you an insight into areas that the judge might want more information or that might be troubling to them, and so I think you respected that. I know sometimes we kept you mired in an area that you wanted to move on, but you humored us, even when you realized that you were about to run out of your time and maybe not get to a point that you really wanted to make, but you still stayed with us and you didn't say, I don't want to talk about that, Judge. I want to go talk about what I want to talk about. So I thought it was very helpful. Judge Watford started off by saying that you guys, as students, are far better than many of the advocates that we see in front of us, and I would certainly agree with that. And Mr. Urick, who's going to clerk for a judge on the Sixth Circuit, I mean, a couple of years from now, you know, he will call you back and say, you know what? The judge was absolutely correct. You guys are far better than some of the stuff we see here. And so I commend you for what you've done and the attention that you paid to the problem and the law. You handled this very well, and I just congratulate each of you. I like to say that at this point, you know, we're going to pick a winner. But at this point, you know, there are no losers. It's sort of winner number one and winner number two, because all of you are winners at this point. And let me ask if there's anything else from my colleagues before I announce our decision. Well, let me start first of all with the Best Brief Award. The briefs were helpful. They were well done. They were thorough. And looking at those briefs, we have determined that the Best Brief Award goes to the Respondent's brief. Okay. All of you were fabulous advocates, but after a lot of deliberation, the court has determined that the best oralist is Mr. Matthew Glover. And while we're not going to decide the substantive law, but the best overall team and the winner of the 2013 Lile competition is the Respondents. Again, congratulations to each of you, and we now turn it back over to, is it Mr. Urick, or do we do?
The proceedings are over, the court's ruled. Let's thank the judges one last time.